on your appearances, please.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Kayla Crino on behalf of the people. Good morning, Your Honor, Mary Chartier on behalf of John Hager, who's seated to my right.
Good morning, Your Honor. Nicholas Sonberg, now for the Sean Hatta.
Good morning, Your Honor. George Brown on behalf of Mary Ann Henry, who sits to my left.
Good morning, Your Honor. Paul Stavlin appearing on behalf of Ms. Fascinello, who is seated in the corner.
Good morning, Your Honor. Garrett Coder on behalf of Kathy Burton.
Good morning, Your Honor. George Demeanor on behalf of Kathy Burton, who is in the courtroom.
Good morning, Your Honor. Dwayne Sullivan on behalf of Michelle London, who I see is appearing on the screen and apparently can't hear us.
Okay, today was the date and the time that it was scheduled to continue with the defense witnesses. We have one witness present. You can be seated. Any preliminary matters before we have to take this seat?
None for the people, Your Honor.
No, Your Honor, thank you.
No, Your Honor.
None, Your Honor.
No, Your Honor.
Okay, sounds like you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
And have a seat. And if Mr. Giannini had completed his, and so we can move on to the next. Questioning this witness, if anyone wanted to question this witness. Okay, then the people are ready. Oh.
Good morning.
Good morning, Mr.
Yeah,
Sullivan.
you recovered from yesterday.
I believe so. Thank you.
Okay, I'll stay in the briefing.
Thank
All
you.
right. You know Ms. London, correct?
Yes, sir.
You met with her at least on 2 occasions.
Yes.
Okay, and those were at her home.
Yes.
And would you recall, if I told you your report was to April 23rd, 2023, and May 11th, 2023? Did that sound about right?
Yes, sir.
And she agreed to these meetings, correct?
Yes.
She didn't lawyer up, did she?
No, she didn't ask for a lawyer.
Okay,
That's what she means.
you don't recall there being any hesitancy on her part in taking the meeting?
No.
Okay, and did you record both interviews?
Pardon me?
Did you record?
Yes.
And you did prepare written summaries also, as a standard practice, correct?
Yes.
And you didn't delete anything from those recordings, did you?
No.
Okay. So would you agree that regardless of the answers you provide today, the best evidence, at least of what was discussed during those meetings, probably comes from those audio recordings?
Yes.
I'm going to get right to that. Do you have, from your meeting with her, do you have any evidence whatsoever that Ms. Lundgren in any way, shape, or form orchestrated the December 14th meeting?
No.
There have been various documents, not just that have been prepared, that have been, a lot of them submitted as exhibits. Do you have any evidence whatsoever that she had any hand in constructing the documents?
No.
Were you able to determine if she had any experience in election law?
Could you be more specific with that? I mean, she had run for congressional district. So to answer your question, I think she had limited knowledge.
Was it your opinion after studying that 1 to 2 sessions that she had limited knowledge of election law, just based upon your observations?
Yes.
I think there's been testimony that Stu Foster made the call to the delegates, is that correct?
Yes.
Okay. And that was confirmed by Ms. Lundgren, correct?
Yes.
I think that in your affidavit, you referred to her as a, maybe giving a purported elector. She never referred to herself in your meetings that way, did she?
Not in our meetings and social media.
You said not in her meetings?
Not in our meetings, but in social media, she did.
Did you uncover anything that would indicate that she was in any way a leader of that meeting?
No.
Did you uncover any, that she was one of the principal persons at that meeting?
I'm not sure what you mean by principal.
There was testimony that an individual took people upstairs and advised them. She was not in that role, was she?
No.
Were you able to determine that her experience within the Republican Party at that time was fairly limited?
I would say that she had some experience with the Republican Party to the extent on how vast that was. I have just the statements that she provided, and I would have to refer to my notes about what she said in terms of her experience.
Could you determine, do you recall whether she had ever been successfully elected to any position?
She was elected to this, I forget which district, I'd have to refer to my notes,
But as a delegate, correct?
yes.
Do you have cover any evidence that she had been put in any position of authority within the Republican Party other than being elected as a delegate?
I don't recall that.
One of the modern techniques of law enforcement is getting social media. Correct.
Yes.
And normally if a person won't turn it over to you, you have to go get a warrant for it. Is that correct?
Yes.
Is it a fact that Ms. Lundgren freely gave you access to whatever you asked?
Yes.
She did that without hesitation, didn't she?
Yes.
And she allowed you to search any and all folders that you wanted, correct?
Yes.
And in those folders, I'm gonna give you some, but not all the names. You found a Charles Bundren, correct?
Yes.
A Eric Cardall,
Yes.
Sean Flynn.
I don't recall Sean Flynn.
Okay.
I would have to look at my notes.
Stuart Foster,
Yes.
Laura Cox,
I don't recall Mrs. Cox. I have to look at my notes.
Chip Chamberlain.
I would have to look at my notes for that.
You probably asked to see if she'd had contact with any of the other electors, is that correct?
Yes.
Do you recall if she'd had any contact, social media contact with any of the other electors prior to what has been testified to was a Stuart, Stuart, I'm called Schaefer, but that's a former prosecutor, Stuart Sanders call.
Could you repeat that question again?
Had were you able to find any social media contacts with Michelle and any of the other delegates or electors?
I don't recall what contact she may have had with the individual ones. I do know that she had social media pages. What were you asking me about Stuart Sandler or the elector?
Stuart Foster.
Stuart Foster.
Stuart Foster.
Okay. I don't believe Stuart Foster.
And you were able to check her social media prior to the December 14th meeting, correct?
Yes.
Okay. Well, because you're investigating conspiracy, right?
Yes.
And so what I'm not saying you're hoping to find it, but what you were looking for is to see if there are any communications that could be later statements of co-conspirators, right?
Yes.
Okay. You didn't find any in hers, did you?
For the electors?
For the time prior to the December 14th meeting.
I would have to refer to my notes on that.
But your notes would clarify that.
Yes, the social media postings and whatnot.
And your notes are accurate, correct?
Yes.
So So if they don't show anything, then there isn't anything, right?
Yeah.
Let's go post December 14th. Did you find any social media between Michelle and any of the other electors following the December 14th meeting?
Again, I would have to refer to the notes on that.
Okay. And so, as with your prior answer, if the notes did not show anything, then there isn't anything there, correct?
Yeah.
And although she has been charged with conspiracy, you don't independently recall if she's ever made any statements in further of that, at least today, correct?
I don't recall.
That was with the delegates. Did you find any social media posts, interactions, let's just generically call them communications, from Michelle to any of the other persons that have been variously identified as leaders or constructors of this meeting?
I would have to refer to my notes if you want to be more specific about names. That may help.
Do you have any names?
Again, I would have to refer to my notes.
Okay. You've worked on this case for what, a couple of years now?
Not quite that.
A year and a half?
About a year.
67 hours a day?
Pardon me?
Did you testify like sometimes 60 to 70% of your time?
Yes.
Okay, so it's almost like a job.
Yes.
Okay. I mean, in and of itself, just this investigation, correct?
Yes.
Okay. Did you uncover anything, any evidence that Michelle Lundgren knew what a certificate of votes was?
I would have to refer to my notes on that.
So you don't independently recall?
That's correct.
Okay. Do you independently recall whether she could explain the significance of that document?
Again, I would have to refer to my notes on what she said in the interviews.
And you'll adhere to those, and as we stated before, you would adhere to the accuracy of the statement in those interviews, is that correct?
Yes.
Did you, in your interviews, do you recall if she understood, in your opinion, what a certificate of payment, ascertainment was?
Again, I would have to refer to my report on that.
In her interviews, Michelle frequently indicated and admitted to signing what she termed a sign-in sheet. Is that correct?
Yes.
That's in hearsay.
Well, it's a statement of the defendant. I mean, it'd be a statement against her interest because it forms the basis of the conspiracy.
Yes.
And that's all she ever referred to it as. Is that not correct?
Yes.
And didn't she further indicate to you that the first time she heard about the certificate of votes was actually from a media posting?
I don't recall that.
But again, the interview would clarify that, correct?
Yes.
You'll agree to that the best evidence would be that interview, correct?
Yes.
Did you find any evidence that Michelle stood to profit financially in any fashion?
No.
Did you find that she stood to acquire a position of power or anything from signing the sheet?
No.
And there's already been testimony from other witnesses that indicate that you don't personally know whether that sheet was ever attached to the certificate of votes, do you?
At what point.
Inartfully worded question, let's limit it. During the time that it was signed in the basement of the Republican headquarters, you don't personally know whether that sign-in sheet, as you admitted, Ms. Lundgren has called it, was ever attached to a certificate of law proceeding.
I received a couple of different reports. Reports that indicated that there were several documents on the table with that sign-in sheet. And then some other reports that just said that there was one document.
Is it you're telling me that you received reports as a fancy way of saying, I don't know personally, but I was told this?
Yes.
Thank you. Did Michelle specifically tell you, well, let me back up a bit. She's a very talkative person, isn't she?
You asking me to offer my opinion on that?
Yeah.
I wouldn't say that she's any more talkative than the next person, although she did tell me she likes to talk.
Okay. And do you recall her demeanor during the interviews? Do you recall her demeanor during the interviews?
Yes,
And how would you describe it?
she was pleasant, cooperative.
Cooperative. She wasn't withholding anything, as far as you could tell, correct?
Yes,
Okay. What is your prior background again before you became a special agent?
it's been law enforcement.
Okay, and have you had the opportunity as a law enforcement officer to conduct many interviews?
Yes,
Okay. And would you pride yourself on having conducted many interviews, of getting a good sense of whether you were being lied to or told the truth?
I would say that that's a goal to determine what the truth is.
Were you a good officer?
That's an opinion that other people make about me.
What's your opinion?
My opinion is that I was an officer.
Okay. But you have this position of the Attorney General, correct?
Yes,
And you're in charge of what you'd have to admit is a very important investigation, correct?
yes.
This is a very publicized case, correct?
I think all of my investigations are important.
But you're able to devote 60 or 70% of your time just on this case, correct?
Yes,
Every attorney will be stricken, so I won't go there. Did Michelle ever tell you that she intended to replace any authorized Democratic electors?
Objection, Jason.
Repeat your question, did she ever tell me she intended to replace any authorized?
Authorized Democratic electors, again, goes to the my same response goes to the very heart. They're charging conspiracy to put in Republican electors in place of duly authorized Democratic electors.
Still here, so.
Correct, but why would it not be statement against her own interest?
Well, he's asking if she said that, not that she said it, so it's not a statement against her own interest. It's the opposite.
He's asking if she said it, if she made that statement.
And the answer,
You're saying it's hearsay, that
I'm saying that the answer would be hearsay because you're getting it
if it
from
was
the
her
defendant.
statement,
Yes.
Your Honor, in addition, it will be affecting the listener.
It would not affect our listeners.
that is not the opinion. That's being off for the truth of the matter asserted. I'm trying to identify why it would not be statement against her own interest. Your question was, did she tell this witness?
Right. So she intended to replace duly elected Democratic electors.
It's only a statement against her own interest if she said that statement. If the answer is no, it's not a
I
statement.
don't know if he's cross-examining. I don't know if she said that. Is it because what if he had said, isn't it true she said, or didn't say? Like that, I don't know if she said it or not. What if she did say that? Then it would be a statement against her own interest, correct?
Yeah, can we approach it and make it on for proof?
It may. Imaginary way. Objection is sustained.
Did Michelle display any anger during either of these interviews?
Yes.
In fact, was the anger directed at the Republican Party?
Yes.
Why?
Well, it's more directed.
I'm gonna object and ask that a foundation be laid that his answer is a derived from hearsay.
Did she
You
indicate?
look, I'm assuming that you don't know the answer, so I'm gonna sustain the objection.
No, I think she asked for more foundation.
Correct, so you didn't respond to her objection, so I'm gonna sustain.
That's all. Was the proffer agreement that you did with Mr. Renner, was it the first proffer you had ever done
On this case?
on any case?
No, sir.
Okay, you've done lots of proffers?
Could you be more specific about lots?
Okay, sure. Well, I mean, I'll let you put a number, or, you know, like that, I'll suggest some numbers.
Been a few, it's been a few.
Okay, more than 10?
No.
Okay. Would you agree that a proffer is a transactional arrangement?
I don't know if I'm qualified
Okay.
to say that.
I'll break it down. Proffers usually involve you wanting to get important information relating to a criminal investigation you have, correct?
Yes.
And have you found, like those of us in the criminal justice field, that often the more information you have that a person has, the more valuable that proffer can be?
Yes.
And you proffered Mr. Renner, didn't you?
Are you referring to me specifically?
They
I
did.
was involved in the property.
Okay.
Yes.
Because he had lots of valuable information, didn't he?
Yes.
So valuable that he's become a state witness, correct?
Yes.
Now, you can't tell me what she said, but you can indicate that Michelle was angry, right?
On the day that I interviewed her?
On one of the days that you interviewed her.
Yes.
Okay. You didn't proffer for why?
Because this was my first attempt to interview all of the electors, or all of the defendants, I should say. And so as I made my way down the list, Mrs. Lundgren was willing to speak to me.
In fact, that was never an issue. She was always willing to speak to you, wasn't she?
Yes.
So why did you make a decision, or why didn't you make a decision to proffer somebody that was clearly willing to speak to you about this case?
Mr. Sullivan, I don't make the decision.
Silverthorne.
Pardon?
Silverthorne,
Sullivan. I'm sorry. I
That's okay.
don't make the decision to proffer someone.
don't you? Who does?
I don't know who specifically makes that decision.
But you're the
It's-
lead investigator on the case, right?
Yes, sir.
And the people who make decisions based upon information you provide, correct?
Yes.
And they base it on suggestions you might have, correct? Because you know more about the case than they do, correct?
I don't know what they make the decisions based upon. It's likely an attorney that makes that decision.
Isn't it a fact that you didn't that that you didn't recommend a proffer for Ms. Unger because she didn't know anything?
I don't, could you repeat that question? I just wanna make sure that I'm accurate in my response.
You had, I'll lay a little bit, you had 2 long interviews recorded interviews with Ms. Unger, correct?
Yes,
And you had the opportunity, because she willfully gave all of her social media that you asked for, correct?
yes,
And presumably, you reviewed all that social media, correct?
yes.
And you didn't proffer because after an interview and after reviewing the social media, you didn't think she had anything of value to add to the prosecution of this case, correct?
No, that's not correct. I don't make the decision to proffer somebody. The attorneys make the decision to proffer based on the information that I provide. So I'm not involved in that decision-making process.
So if you told your superiors, we really have to get this, she's on board, she hates what's going on here, she's willing to talk to us, they wouldn't sit down with a proffer, authorize you to have a proffer?
They have my reports, sir, and so they would make that decision.
Do you independently recall having discussions with your superiors about whether a proffer would be worthwhile?
For your client?
Yes.
I don't recall that.
Let me just get some clarification. Do you have the ability to seek or request to proffer somebody at all?
I don't believe so, no.
Oh, so
No, I don't.
you don't believe so, or is that?
That would be a no.
It's up to the attorneys to determine if they want to proffer someone. So I provide the information. I don't recall participating in that discussion.
In some of your prior proffers, and please borrow from me, I might wander a bit. In some of your prior proffers, charges weren't outright dismissed against those defendants, were they?
Objection, relevance.
If I could be permitted.
You want to be permitted to, for you to
Where-
respond to whether or not it's relevant?
Yeah.
Well, why do you think it's relevant?
I'll get to the question and I'll just get to the question. Were you in favor of, and so I will withdraw the question so that you can respond to the objection. Were you in favor of the charges being dismissed entirely against Mr. Renner?
I didn't weigh in on that part. I'm not involved in that decision-making process.
Who would be?
I don't know, somebody at the AG's office, an attorney on this matter.
Okay, so you're not involved. Okay, but you have opinions, right?
I do have a
It's not unusual for you to make reports and then later disagree with how your superiors handle those reports, is it?
It's not unusual for me to make reports.
To give reports on cases
Yeah.
and then have them handled in a manner that you personally don't think they should be handled.
I respect their decisions.
I didn't say that. Is
I'm
that-
not sure what you're asking.
So, are you saying that as an officer, that every decision that your superiors have made at the AG's office and earlier, you thought they made the right decision based on the information you provided?
Objection, relevance.
I would thought. Okay, I'm gonna go a different area. You've heard testimony that there are some unindicted co-conspirators. You actually offered that.
Yes.
Are there other unindicted co-conspirators? And I'm gonna read you a list of names and you can just respond yes or no.
Okay.
Stu Foster,
No.
Tony Sandler,
No.
Laura Cox,
Yes.
Stu Sandler,
Yes.
Troy Hudson,
No.
Tom Leonard,
Yes.
Janelle Leonard,
Yes.
Chris Velasco,
Yes.
Rudy Giuliani,
Yes.
Jenna Ellis,
Yes.
Mark Meadows,
Yes.
finally, former President Trump.
Yes.
Do you believe Mike Pence is considered a victim of these charges? A victim of these allegations, these alleged charges, excuse me.
Charges?
Yeah. Who is the victim of these charges, if you know?
People of the state of Michigan.
No evidence that anyone's lost any money?
No.
No evidence that anyone has lost anything of that tangible value?
No. Good morning, sir.
I just wanted to follow up on a couple of things that came up yesterday. Some of the facts here. One thing that you said yesterday is that in doing your investigation, you did look at some of the other lawsuits that had been filed that were alleging there was voter fraud.
Yes.
Okay. And I'm confining my question to the state of Michigan. And so you were aware that there was a lawsuit that was filed in federal court that was entitled King versus Whitmer.
Yes.
Okay. And in doing your investigation, you prepared an affidavit, did you not, to obtain records from the from Facebook, Meta. Yes.
Yes.
Okay. And in that affidavit, unfortunately, I don't have a printed copy, but you recall stating in paragraph 22, on November 29, 2020, Republican candidate for electors Timothy King, Marion Sheridan, and John Hager filed a complaint in the U.S. Eastern District Court, Michigan, alleging voter fraud. They sought an injunction to stop the governor and secretary of state from transmitting the certified results to the electoral college. The court did not find sufficient evidence and dismissed the case. Did you say that in the affidavit?
Yes.
Okay. And in stating that the case had been dismissed, you knew it was dismissed because you could look that up and find out what happened on the case?
Yes.
Okay. And one of the things that, in looking it up, there's like an internet service called Pacer, you can look up what happened on federal cases.
Yes.
Okay. And in this affidavit, you say that the matter was dismissed. What you did not state there is that the matter was dismissed on January 15th, 2021. Is that correct?
I'd have to refer to the report.
Okay. But you were saying yesterday that you'd have to see your notes, or are you talking about the police reports?
Well, that's all encompassing. So
Okay.
if we're talking about a specific matter, then the documents associated with that matter.
Okay. I'm just saying yesterday when Mr. Demeanor was asking you questions about certain facts, you said I have to look at my notes. You're talking about your personal notes, or you're talking about police reports when you say that?
That's what I'm talking about. By everything. So if we're talking about a specific subject matter, for example, Mrs. Lundgren, we're talking about police reports to an end. If we're talking about a court case, there may be a report on that, or social media, there may be a report on that, or the actual social media posts. Does that help you?
Sure. When you're interviewing someone regarding your investigation, in this case, you get notes while you were interviewing them.
Yes.
Okay, do you still have those notes?
No.
Do you recall, or will you agree that the case that you referred to, entitled King versus Whitmer, was still pending as of December 14th, 2020?
I don't recall that.
All right, now in, yesterday there were a number of questions about who it was that had actually mailed the plaintiff's exhibit number 14, had mailed that document to the National Archives and to the other entities that was mailed, right?
Yes.
Okay. And I think one of the, well, in regard to your submitting an affidavit for probable cause of the charges here, you indicated that in order to prepare that, you did research about the statutes
Yes.
under which they were charged, right?
Yes.
And one of the charges in this case is uttering and publishing, right?
Yes.
Uttering and publishing, you know from the statute requires that a document be published and transferred to a third person, right?
Yes.
Okay. And so that fact that this was mailed out, sent to another person is an important fact to you, correct?
Yes.
All right. And determining who mailed that out would be important to know, right?
Yes.
Okay. Now, I'm going to hand you what I've marked as this is. I got it. Oh, I'm used to it. I'm just saying. They hand you that in your check, and it's marked as Defendants Proposed Exhibit L. And you recognize that, do you not, as an email chain? And unfortunately, you have to go start in the back.
Oh,
Goes-
okay.
One of those that goes from the back. In time, you have to start in the back.
Okay.
So, this is an email chain that you had acquired, I believe, from Mr. Chesbrough, right?
Yes, sir.
Okay. And it's dated December 15th, 2020, correct?
Yes.
And do you recall then from this email chain that it begins with Sean Flynn sending this email to Mike Roman, G. Michael Brown, and Ryan Terra, correct?
Yes.
And all of those individuals, you look up on the page, refresh your recollection, you can read it, all have email domains of DonaldTrump.com. Sean Flynn, Michael Brown.
Yeah, those three. Yes.
Yes. Not
Right.
them two.
And
Oh, not Terrell.
Terrell has the GOP.
Yep. So, but Michael Brown and Sean Flynn, are both DonaldTrump.com, correct?
And Michael Roman, yes.
So the
This begins with Sean Flynn's email to Mike Roman, Michael Brown, and Ryan Searle, correct?
Yes.
And indicating, if you look at the back page, he has two questions. And those two questions are, how's this thing supposed to be mailed out?
Yes.
Okay. After that, then, apparently, Mike Roman then includes Kenneth Chesbrough in this email chain. You see that is the next email going up the page?
Yes.
Right. Now, after some back and forth with Mr. Chesbrough, and then on December 15th, 2020, Sean Flynn says, I'm looking at back of the first page. Sean Flynn says, I have prepared packages for each of the following. And lists the people that are the entities that he's going to send this to, correct?
Yes.
He sends that email off. He gets a response from Mr. Chesbrough. And then Sean Flynn says at 2:40 in the afternoon on December 15th, on the front page of your exhibit, he says, does he not, the Michigan Post Office, I went to, suggested putting the entire external envelope into a priority flat rate envelope sent with certified mail and registered mail as necessary. Essentially, that registered/certified mail is just an extra service, so I need to choose a class of mail for the postage. That's what he said, correct?
Yes.
Okay. Now, someone who aids or assists another person in the commission of a crime in Michigan is as guilty as the person who actually commits it, correct?
Yes.
And publishing the document, People's Exhibit number 14, to these other entities is, as you said earlier, an element of other than publishing, correct?
Yes.
And the question I've got for you is, you could conclude from this, could you not, that Sean Flynn mailed out this package to the Senate and to the Archives Office?
I would say it suggests that.
Okay. And that would make him an aider and abettor in this case, wouldn't it? He sent that?
I think you have to take not just this bit of information, but all of the information.
Okay. So, understanding all this would make him an aider and abettor in this offense, wouldn't it?
I think it would be evidence
Okay.
suggesting that he assisted, participated.
Okay. Now, in regard to how the charges arise in this case, you indicated earlier yesterday that you prepared an affidavit of probable cause about each of the defendants in this matter, right?
Yes.
Okay. And then you submit that to a judge seeking a complaint signed by, or a warrant signed by the judge, right?
Yes.
Okay. And you did not do that in regard to Sean Flynn, right?
Yes.
In regard to the affidavit that you prepared for each of the defendants, in this case, I think yesterday you said that you prepared paragraphs 1 through 37, is that what I understand?
Sounds about right.
Okay. 38 through 45 were prepared by a lawyer, correct?
Yes.
At the Attorney General's office, right?
Yes.
And then you took that, signed it, that affidavit, correct?
Yes.
Attesting to whatever was in this was true, even though the lawyer put in additional paragraphs that you didn't have in your probable cause affidavit.
Yes.
Right? Okay. In yesterday's question, Mr. Demeanor had asked you about 1960 Hawaii, the facts that occurred in that case. Remember those questions?
Yes.
Okay. And I think one of the things that you said that was important to you was the fact that the electors for both the Republican and Democratic slates had met together. Is that what your understanding of the facts were?
Yes, there was several things that were different. Yes, they met together.
Okay.
There was a recount in the margin between the two parties in Michigan was 150,000. In Hawaii, I don't remember what the margin was, but I remember it was much smaller.
Okay. In regard to the meeting together, did you interview in your investigation, did you interview Governor Whitman?
No.
Therefore, you don't have any evidence as to whether or not the governor had invited any of the Republican electors to be present during the December 14th, 2 o'clock meeting at the Capitol.
Could you repeat that?
You don't have any evidence that the governor had invited any of the Republican electors to be present during the counting, or I should say the vote that occurred on December 14th at 2 o'clock in the afternoon.
That's correct.
Okay.
Yes.
Going back to your affidavit of probable cause, in the paragraphs that you prepared, at the point that you had completed those 37 paragraphs, in your mind, that was sufficient for the court to authorize charges against the individuals that are charged in this case? Yes?
Yes.
The Attorney General had added additional paragraphs, Assistant Attorney General, right?
Yes.
Okay. And so, in regard to signing this affidavit, you relied on the lawyer's advice about how this affidavit should look and when you signed it. You relied on what they told you.
They recommend the charge.
And so you relied on their advice of recommending charges to sign this affidavit.
Yes.
We talked about the fact that you had prepared a search warrant for records from Facebook or Meta. And you also prepared other search warrants in this investigation, correct?
Yes.
And one of those one of those search warrants that you asked the court to authorize were for records from Give, Send, Go, correct?
Yes.
Okay. And in your request for records, in that search warrant request, let me back up. In getting a search warrant, you prepared the actual search warrant, correct?
Yes.
And
Forget, sign, go.
Yes.
Yes.
It's in Go. And the affidavit in support of that search warrant request, correct?
Yes.
And you turn both of those over to a judge who signs the search warrant, provided the probable cause in the affidavit.
Yes.
And in that search warrant, you were seeking not only the records of accounts that were, apparently there were 2 accounts with Give, Send, Go that you were looking for information on, is that right? Or one accounts with Give, Send, Go?
There was 2 accounts? There was one account for each defendant that was on it.
In that regard, then, you have to list in your search warrant all the things that you're looking for, right?
Yes.
Items that you want to seize.
Yes.
And information that you wanted from Give, Send, Go included the account information, and I should say bank account information of individuals that had donated money to these accounts, correct?
I don't recall specifically that information.
All right. And if you, can you think, if you did, let's put it this way, if you did ask for the bank account information of the donors to these accounts, can you, what information that would be relevant to your investigation in this case would that have provided you? If you had the bank account information for donors?
So there is a lot of information that I'll request without referring to the affidavit itself. I don't recall. As I said yesterday, a lot of that information is to show ownership to the accounts. The accounts can also, they can be created, they can be edited, so the statements that are made in the accounts can be edited as well. So, like, for example, in social media posts, they can be edited and you're looking for an audit trail of the edits. So again, I said yesterday, I was focused on statements. The associated information I'm also asking for is to show ownership of who created the account and to connect those statements or the account holder with that information.
All right, so if I understand how this works, Give, Send, Go is, if I wanted money from people, I would set up an account with Give, Send, Go, and then send out requests for money to people on the internet.
Yes.
Okay. And then if someone reads that and decides they want to give me money, then they will authorize a transfer from their bank to Give, Send, Go in my account. It Give, Send, Go. Is that how it works?
I don't know specifically the procedures that Give, Send, Go has in place. If you're asking me that, the technical procedures of
No,
how they route the money.
All right, can I just think of it this way? I have an account with Give, Send, Go that people donate money to.
Yes.
Is that right?
Yes.
Okay. All right. And those people that donate money, Give, Send, Go, is it your understanding, records who gave money and how much?
Yes.
Okay. And can you think of, why would you want to know the names of the donors to or the bank account information of the donors, as opposed to just the owner of my name and the Give, Send, Go account? Why would you care who gave me money?
That's not a focus. So Give, Send, Go uses a third party to handle their financial transactions. That's what I learned on the return information. So I did not submit a search warrant for the third party financial institution.
Right.
Because I'm focused on the statements and how those statements are tied to the defendants and to show ownership of them, the statements that are made in this. So that's the information that I'm focused on.
I'm asking open-ended questions here, and I appreciate that. But I'm just trying to figure out, why would you want to know the names of the donors?
I just explained that. I can explain it again.
To show the ownership of it.
To show the ownership of the account. There's, as we ask for information, I'm trying to connect the person that made statements on that account to the people who are may have edited it, may have created it. I'm trying to show ownership there.
Ownership of the, back to my example.
So they
You want how much money is in my account that Give, Send, Go?
I'm not concerned about the amount of money that's going into your account.
You want to show I own that account?
I'm concerned and focused on who owns the account and the statements that are made.
Okay, by the subject of your.
Give, Send, Go uses a third party to handle donor, to handle those financial transactions. Did not have access to that information.
But you did ask for the information of the names of the people that gave money to my account. As an example.
I don't recall that.
I had asked you earlier about notes that you kept while you were doing your investigation. You said you kept those. And, so, I assume you said you don't have any of them anymore, right?
Well, and with the exception of this past week, I have notes that I used to create for this exam.
Okay.
So, but going back, I don't have any of the notes. The notes are transcribed to a report, and then shredded.
Okay. So is that the normal course of your, any investigation that your notes destroyed prior to someone being charged?
Yes, handwritten notes. That yes, I take that information, transcribe it in a report, and then destroy the evidence.
Okay. And so to finish that, you said they're transcribed. What do you mean?
I review what I've written down and then type that out.
Okay. You type your police report using your notes to refresh your memory about what somebody said or what you found.
Yes.
It's not verbatim transcription of your notes to your police report.
It's close. You know, I use the notes along with the audio recordings if I have those as well.
I don't recall, do you have prior law enforcement experience before the HE's office?
Yes.
Where was that?
I worked at Meridian Township Police Department and Beverly Hills Public Safety.
Okay. And in the fact that you shred your notes that you were just talking about, is that something that is a policy with the investigator's office of the Attorney General?
No.
Is that your own personal method of handling that?
I do those notes confidential, and I don't want them to be lost or misplaced or anything like that. And over 26 years, I would have an awful lot of filing cabinets in order to accommodate all those notes. So the information is transcribed, as I said, down on a report, and then that information is shredded.
A report that you prepare yourself?
Yes, anything that has my signature on it.
And in regard to those, I'm not saying keep your notes going back to Beverly Hills Public Safety Department, but what you're saying is you don't even retain your notes to the point where someone is charged with a crime and he has to retain themselves.
Again, I said to retain notes over 26 years as an investigator would require a lot of filing cabinets. So I hold on to the notes until that information is put into a report. That report is approved by my supervisor, and then I no longer need those notes.
I don't think that was the question.
So what you're saying is you don't even hold, I'm not saying hold it for 26 years.
No,
You don't hold them until even until a case is charged. You don't keep them that long.
No, once the report is approved.
Then you shred them immediately. Close to.
Close to.
One second. Thank you, Judge. Sorry. I'm paralegal. I was pulled up the affidavit for the Gibbs and Row. And looking at that affidavit, refresh your memory as to whether or not you asked for the identities of donors, the bank account information of donors, and routing numbers and that sort of donors to the gifts and go accounts.
Yes.
Okay, with that.
Are you going to start here? Yeah. No, I'm good. Oh, yeah. Yeah. Yeah.
If you ask for information from Gives and Go, you ask for the identities of the givers, that's the donors.
Yes.
You ask for their routing numbers for their bank accounts.
I didn't see routing numbers. Routing numbers. Yes. Yes, sir.
And you ask for bank account numbers
Yes.
and the amounts that they provided or given.
Contributions.
All right. Now, so understanding that, can you explain? The thing is, why would you want to know the bank account information of people that are donating to my client?
Because I'm trying to determine if that, again, is owned by your client. So is that money going into your client's bank account?
No, why would you? I'm talking about the donors, not the Gives and, not where the Gives and Go money is leaving Gives and Go and going somewhere. If my client has an account with Gives and Go, why would you want to know the names, the routing numbers, the bank account numbers, and the amounts that donors have given her?
Like I said, to show where the money's coming from, how it's, where it's coming from and going into that account.
I'm trying to get clarification. You wanna know where the donor's money is coming from?
No.
What money?
I'm trying to establish ownership of the account. And to establish ownership, I'm looking for names, dates of birth, email addresses, accounts of your client to show that she owns the account, that money's going into her account.
Right.
That's what's causing me confusion. How is getting the donors gonna provide you that information versus asking Gives and Go for the owner information?
So the donors, I'm not concerned about. I'm concerned about the path, the money coming in. So that, am I concerned about it, in terms of just, how do I describe this? So, I'm trying to articulate it in a manner that shows a pathway. So that, just like that metadata that we talked about with social media, that shows dates, timestamps, the transfer of information, I'm looking for the same thing with this type of account. So that's why I'm concerned about the donor, of the account, or the donor, and where that money's going into her account.
And you can understand I don't know that really answers the question, because you're asking for the bank account information of somebody that's not a defendant, right?
No, I'm asking for the bank account information for the defendant.
It's not what it said in your search warrant, did it?
That's what I interpreted as.
When you ask for the names of givers, and bank account information of givers,
It says
routing
just,
numbers of givers,
it says just bank account information. It's not, I'm not focusing on the givers. Again, I'm focusing on the client.
But you asked for the routing numbers of the givers though?
I'm asking for all routing numbers and bank
Of
account
the-
numbers.
Yes or no? Did you ask for the routing numbers of the donors?
Yes. No, I'm asking for the donor.
I don't know, I'm gonna have to see the search warrant at this point. 'Cause
Yeah,
I can't get straight on
I'm
the
kind
answer.
of confused by the question.
because if we could print it, unfortunately I didn't print it.
Okay, it's about an hour, we should take a break anyways, I don't know if you want to, email it to, Mr. Deeds, if you can get it printed
Paul?
for you all. off the record, or you can get
Yeah.
2-minute draft
Michelle? Nice. Michelle?
And then you're the city boy. They moved to their house and we had a costume like a house like that.
Oh,
Here she goes.
Yes, I thought, I thought you were seeing it. Sit down, sit
Okay,
down.
back on the
Get
record.
you a picture.
thank you, Agent Shock, I'm going to hand you what's been marked as defendant's proposed exhibit N. During the break, you had the chance to review your search warrant and affidavit that you sent up to both.
Yes.
And records should reflect that technical Attorney General as well. So take a look at that. That is what we're talking about, right? The first 3 pages would be the search warrant itself. There's a tabulation and return, and then there is your affidavit
Yes.
all there. Okay. And that was signed, so we get our timing down here. That was signed by Judge Ward on August
29.
Yeah, of 2023, correct?
Yes.
The defendants in this case had all been charged already, right?
Yes.
Okay. And I want you to turn to, then, I believe it's the 3rd page at the top, there's a subparagraph F. Do you see that?
Yes.
Okay. And that's what we were looking at earlier, when you were looking at the computer that Chartier had?
Yes.
Okay. And you agree with me that that subparagraph asks for information from Give, Send, Go related to Amy Fashion Lowe.
Yes.
Okay. And that subparagraph asks for the givers, the people that donate money, right?
Contributions?
No, givers.
Givers, yes.
Okay. Contributions, meaning how much money,
Yes.
right? Okay. And then asks for all of routing numbers, bank account information, tax ID numbers for those individuals, right?
No.
Okay. It says there that it looks for that information as it relates to the people listed above, right?
No, for the subscribers page.
Subscribers page for those listed above.
Yes.
Okay.
Yes.
And donors and contributions are above that statement in your affidavit, right?
Yes.
Okay. But you did ask for specifically then well, you can understand someone reading that would say you're looking for the bank account information, meaning routing numbers, bank account numbers, tax ID numbers, of not the defendants, but the people giving money to the account. You can read it that way, right?
If the people at Give, Send, Go, their legal compliance were to read it that way, then they could contact me for further clarification.
So you can understand that this was a search warrant that you executed after the individuals in this case had been charged, right?
Yes.
Okay. And the accounts that you were looking for from Give, Send, Go were entitled Legal Defense Fund, right?
Yes.
Okay. And you could understand that when someone who is giving money to a Give, Send, Go account for one of these individuals that are charged here, when they find out that the Attorney General is asking for information about their routing numbers, bank account information, and their tax ID numbers, that would have a chilling effect on their desire, wouldn't you?
Objection, Your Honor. Mischaracterizes the testimony, relevance, speculation.
Did you want to respond to those objections?
So I'm asking for his opinion in regard to, well, let me ask it a different way.
Okay.
I'll withdraw that question. Before you prepared that affidavit, was that affidavit reviewed by anyone of the Attorney General's office.
Yes.
And, getting the names and amounts contributed of those people that are donating to the legal defense funds, was that something you put in or the AG put in?
No, I would put it in.
Can you tell why it is that you would wanna know the names of anybody giving money so that these people could have attorneys represent them in this thing?
Not looking for their names.
You asked for the givers, that's clear, right? No misunderstanding there, right?
Yes.
And the amount given, contributions.
Yes.
And so my question was, why would that be relevant to your investigation?
To show ownership of the account.
How does knowing who gave money to an account show ownership of the account?
I'm using it's an investigation tool that we use to establish ownership. As I've mentioned before, there's transactions that come in and go to a specific account, i.e. the subscriber's page. They're linked. The link to the subscriber's page. So that's what I'm doing, trying to establish ownership of that account.
So the name of somebody who gives money to a defendant here, pay for their lawyers, shows ownership of the account to you.
I didn't say that.
Why is it important to know the names of the individuals donating money?
It's important to know the route, the money coming and going, coming from one place to the next to show ownership to that account that the money's going to.
All right, that's your answer.
Yes.
Your Honor, I believe, I would ask the court, because the court had questions, I would ask the court to admit defendant's proposed exhibit M, those defendants M.
Any objection?
Again, it's not offered for the proof of the matter asserted therein, it's just to impeach this witness.
I don't have any question.
Defendant's M is admitted. I think you did provide him with the defense L. right?
He's got the only copy, Judge, so.
Okay, well, I mean L though, as in Larry.
I did not move for admission.
I was gonna say you never moved for that, okay.
No.
You want to get your own?
Yes, thank you.
Mr. Silverthorne had asked you questions about individuals you consider to be unindicted co-conspirators, right?
Yes.
Okay. You would have reviewed the email chain that I gave you that was in Defendants Exhibit L, Proposed Exhibit L, right?
Yes.
With Kenneth Chesbrough
Yes.
giving advice as to how the People's Exhibit number 14 should be sent off to the archive and to the Senate entities. Remember that?
Yes.
And someone who assists in the commission of a crime, whether by word or deed, is a aider and abettor and is as guilty as the people they do it, correct?
Yes.
Okay. You would consider Kenneth Chesbrough then an unindicted in this case, unindicted co-conspirator in this case, correct?
Yes.
Nothing for me.
Mary Ann Henry has no questions, Your Honor.
Any questions?
Yeah. With the first permission, so we can. We'll try and do this in reverse if I can, listen. Investigator shock as it relates to Defense Exhibit M. Looking at, I believe it was, the third page. Subparagraph F. Do you recall testifying about that?
Yes.
Now, when you're referring to the subscribers page of those listed, would that be the person's, the donors, or the person's named in, paragraph B?
The person's named in paragraph B.
And those would be the listed defendants for the Slate Electors, is that correct?
Yes.
And so ultimately, the purpose of Defense Exhibit M, what information are you looking for?
Subscriber information, account IDs, trying to establish ownership of the account and focusing on statements that were made on the pages and then any edits that were made to those statements.
And did I hear you correctly on cross-examination that GiveSendGo did not send you donor routing numbers and donations?
That's correct.
And you did not submit a subsequent search warrant seeking that information, did you?
No.
As it relates to notes that you take during your interviews during the investigation, you testified that those notes are eventually destroyed, is that correct?
Yes.
Now, the reports that you will prepare, are those based on your notes?
Yes.
The interviews that you take, are those recorded?
Yes.
And are those recordings preserved or destroyed?
No, they're preserved.
So for every interview that you have done in this case, there is likely a corresponding audio recording as well as a written report?
Yes.
Your affidavit for probable cause, the paragraphs that were not authored by you, 38 through 45. What's contained in those paragraphs?
The count of the charges.
And as the investigator of the case, are you responsible for determining the charges?
No.
But you read those paragraphs, correct?
Yeah.
And in order for you to swear to those paragraphs, did you make sure that you were comfortable that your facts in the affidavit corresponded with those charges?
Yes.
And did you in fact swear to the entirety of that affidavit, including paragraphs 38 and 45?
Yes.
Now, during Mr. Silverthorne's cross-examination, he discussed whether or not Ms. Lundgren only stated that she signed a sign-in sheet. Do you remember that line of questioning?
Yes.
As part of your investigation, did you review Ms. Lundgren's social media?
Yes.
Permission to approach, Your Honor? I'm gonna hand you what has been admitted as Exhibit 28. And I'm drawing your attention to the fifth and final page. Meta identifies it as page 5730.
Okay.
And drawing your attention to the highlighted portion. Can you read the highlighted portion, please?
Yes. This was a big Trump legal, there was a big Trump legal team present. They know what needs to be done. I was proud to be in the midst of patriots. We signed all necessary docs. We took photos of all of us. We tried to enter into the building. We were obstructed, but we did everything, and we are well documented. Piece M. Period.
Does it say anything about signing just the sign-in sheet, does it?
No.
I'm sorry, Judge, so if that statement's going, I don't know who made that statement.
I think that was supposed to be, that was Lundgren's
Okay.
Facebook or social media.
Yes.
Thank you, Judge. I'm objecting to that statement being used as evidence against Ms. Fascinello. Obviously, Ms. Lundgren is the defendant in this case, and I don't have the opportunity to cross-examine the maker of that statement. And, so that statement, if it's going to be used as evidence against Ms. Fascinello, it's hearsay.
It's my understanding, I'll read it directly, I'm limited to the scope of cross, and I was directly addressing a statement that was elicited by Ms. Lundgren's attorney, Mr. Silverthorne, that she only signed the sign-in sheet.
Okay, so if it's only used against Ms. Lundgren, that's fine.
Yeah, 'cause
Thank you.
she's gotta address everybody at one
Sure.
time, so.
I got it. Thank you, Judge.
It's a lot of y'all. Kenneth Chester. He testified that he is considered an unindicted co-conspirator in the state of Michigan. Are you aware if he is either indicted or unindicted anywhere else in the United States?
Yes.
Where?
Georgia.
Well, what's the current state of his Georgia case?
He pled guilty. He pled guilty to filing a false document, I believe it was, in an election fraud case.
Stemming from the 2020 election, is that correct?
Yes.
Thank you.
Your Honor, I believe he pled under advisement, and the case will be dismissed against him at the conclusion of that period of advisement.
He still
Just so
entered
the
the
record.
plea. He still entered the plea, correct?
Yes, he did.
Thank you.
He put under advisement and,
In Georgia.
no, I know it was in Georgia, and the plea with, for the,
The case is going to be dismissed against him, so there will be no conviction against Mr. Chesbro.
after a period of supervision, I'm supposing.
Yes,
Okay. And there was a factual basis that was entered.
There was.
May I proceed?
You may.
Thank you. Now, you testify both on direct and cross that your investigation began December 2022, is that correct?
Yes.
And during your investigation, did you basically have to step back into what the conditions were in December 2020?
Yes.
And as of December 14th, 2020, the Michigan electoral votes were certified for which party?
The Democratic Party.
Had a recount been requested?
No.
Had a
Not to my, not to my,
Had a recount been ordered?
no.
The certificate of ascertainment that you obtained during your investigation was for which party?
The Democratic electors.
And during your investigation, did you obtain information about statements made by Mike Shirkey and Lee Chapman?
Yes.
Mike Shirkey was Senate Majority Leader, is that right?
Yes.
And Lee Chapman was Speaker of the
Speaker of
House?
the House, yes.
And was it related to Michigan's election results for the 2020 election?
Yes.
And did that have an effect on you as a listener?
Yes, I think that,
And what were those statements?
I'm gonna object as to hearsay because I think, based on that question, this is not about the effect on agent shock. I think it's to try to get those in as a fact that, for example, Speaker Chatfield and Mike Shirkey indicated that they were going to be certifying the votes for, at that time, soon to be President Biden. And the other thing is, this already was covered on direct when we were here a couple of months ago. And I don't believe that there has been cross on Chatfield or Shirkey's comments. I believe that Agent Schatz brought up Shirkey yesterday, but I think that was brought up on his own. I don't think any lawyer asked about them.
Well, it doesn't matter if the specific question references it, if the answer elicits that information, I'm allowed to redirect it.
Not if he's opening up the door. If he were our witness, then that I think would be a very different story. But she's got her own agent up here opening up the door to comment, so now that the assistant AG can now ask about them.
He's not, they called him as a witness, but he's your investigator.
And actually, the AG called him as a witness.
Oh.
We're
I
just
called him as a
crossing it.
witness.
We're just crossing it.
Okay.
Yeah, no,
But-
I called him as a witness.
Gotcha. And so he's your witness. He was not directly asked by any of the defense counsels about anything that Shirley said.
All right.
Objection sustained.
Well, Your Honor, I still think it's effect on the listener, but I will not put the scene.
Yeah, because again, you're bringing in some statements that they don't have the opportunity to cross-examine.
1600 days.
But
I
that's about
will move
Shirley.
on. I will move on.
And they have to cross-examine for days because it's 6 attorneys. So it takes a while, especially if Demeanor and Coburn are going to
That is fair. Okay. Now, moving forward back to December 2022, when you are actually investigating this, between December 2020 and December 2022, had there been a recount of the Michigan election?
No.
Were the Dems still declared, the Democrats still declared the winners of the Michigan votes for 2020?
Yes.
Had there been any change to the certificate of ascertainment for the 2020 election, naming the Republican slate as the electors for Michigan?
No.
Were there any successful legal challenges on their merits?
Objection, Your Honor. Only because this has been asked and answered. This was covered in direct. There were questions about lawsuits that were still pending on cross. But I mean, this has all been covered.
It was also asked on cross, and I'm allowed to read it.
Right, but redirect on the same cumulative questions that were asked on direct.
I think that's what she's saying, that these were already asked, and so she's asking why you're reading.
I believe there were several questions on cross-examination about the status of legal challenges
There were.
and the pendency, and so I believe I'm allowed to redirect that.
We're not disputing that, but you're asking essentially the same questions, and we're getting the same answers. I don't know if you want to pinpoint the questions or redirect issues that are unclear, because these were issues that were unclear based on his testimony. Yes.
I raised the question about legal challenges in other states. Ms. Logan objected to it, and Your Honor ruled it was not relevant. So, it doesn't exist.
Agent Shock, I believe, had said something like he was not aware of any pending judicial actions. And again, that's a paraphrase when he was asked on direct. And I believe that lawyers asked about pending legal actions at the time. I think again, they kind of call the same direct over again. I mean, I know we joke about, Mr. Coburn, Mr. Demeanor taking the scenic route, but now we are on a scenic route, on a route we've already driven down. Right? At least their route was new. We were seeing new things. Now we're seeing the same things.
Well, Your Honor,
Mr. Demeanor, did you
Well, Your
decide
Honor,
not to speak?
mine is, I was thinking about
to respond.
the
You
question.
are, but
I'm trying.
you want to respond after each? Is that what you want to do?
Well, I don't know.
You can respond to her, but then he's going to say something, then you got to respond again. It's up to you how you
I
want
would
to do it.
rather do that.
Let's do it.
There was extensive cross-examination, specifically naming cases yesterday, during cross-examination. So I believe I'm allowed to clarify the status of those cases in at the time that this investigator took over this case and whether or not, how they were resolved. I'm allowed to do that.
The one thing that's significant though is what, I'm sorry.
Mr. Demeanor had something he wanted to add.
Your Honor, my point is that the fact that these cases were ultimately resolved in favor of the Democratic slate is kind of beside the point. The point that was made is that there was a possibility that these cases could have been resolved in President Trump, former President Trump's favor between December 14, 2020 and January 6, 2021. So when the prosecution is asking questions about what happened in 2022, they can ask that all they want as far as I'm concerned because they don't know.
I did not ask that question.
Yeah,
I
you
didn't
did.
even, I didn't even get a chance to finish my question, actually.
And I believe with Mr. Demeanor, unless they're somehow showing that there's a conspiracy that's ongoing in 2022 and these judicial actions are decided, and I don't believe that's the case, and it's totally irrelevant. What's irrelevant is the intent when this document is signed on December 14th, 2020. And then what might be relevant for intent is what Sean Flynn is thinking when he actually mails the document, since he's an unindicted co-conspirator. But what happened 6 months later or 9 months later is totally irrelevant to what the intent was when this document was signed.
I don't even think she finished her question though.
I do, but I think we're that is in response. That was not the question that was asked, but that was in response to why the question was being asked.
And just for, she didn't finish her list of questions, but that was exactly her question. Her question was, did it resolve, was there a recount, and did the cases resolve ultimately in the Republicans' favor? So
Right,
that's
to-
exactly the question.
To her point, there was questions, I think by you mainly, yesterday, in depth about a number of the cases, and I think you were going along the lines of, could that have had an effect on his, investigation or his affidavit to charge? And so, that's why she's redirecting as to what happened in those cases, is what I'm assuming.
I believe we went into depth about some statements that were in an affidavit. I should be allowed to redirect on those.
I'm overruling the judge.
Thank you. Now, my questions. When you start your investigation in December 2022 and you're looking back to December 2020, specifically the legal challenges, were any of those legal challenges successful on their merits?
No.
Now, specifically talking about the Constantino versus the city of Detroit, which you were asked about yesterday. Do you remember that line of questioning?
I remember the case that asking me, it was a long day, I don't remember the line of questioning.
During your investigation, which started in December 2022. Sorry. Regarding those allegations that you were asked about, were you able to substantiate any of those allegations of fraud in the city of Detroit?
No, I'll just object on relevance. Again, my point is, whether they were ultimately successful allegations does not matter. Were the allegations pending as of December 14, 2020? Yes, they were. Could they have resulted in a ruling in the Republican side's favor? Yes. Were they ultimately successful? No. I don't dispute that. I never made an argument to suggest that the ultimate success of the litigation mattered at all.
You haven't made any argument yet.
To the extent that the court wants to hear about the ultimate determination in these cases, that's fine, but my objection is relevance because it's completely irrelevant.
Well, you brought it up as to the effect it had on his investigation. I'm assuming that's what she's addressing.
Yes.
Okay, let's see what the effect of a successful or unsuccessful case is, I
Well,
guess.
I join Mr. Demean's objection, but I also object on relevance grounds because I haven't heard anything from Agent Chalk that he actually was investigating voter fraud. I've heard that it's starting in December 2022, he was investigating these 16 individuals, but I haven't heard that he was, investigating Antrim County or what was occurring in Detroit or anything like that. I don't believe we've gotten any reports on those investigations. So I think he's limited, his work has been limited to the electors. I mean, that's like saying, have I uncovered voter fraud in Detroit? It's not my job.
He was specifically questioned about that case and if that case had an effect on his investigation.
I would just object to the phrasing of the question and essentially was, did you uncover voter fraud in Detroit? Because I don't think that was his job.
I did not, that was not my question. My question was he able to substantiate the allegations? I didn't ask him if he uncovered voter fraud in the city of Detroit.
Well, substantiating the allegations would mean, what could be interpreted that he was the one doing the investigation.
Well, if the allegations had an impact on the listener, then I'm allowed to ask if he was able to ascertain the truthfulness of the veracity of those allegations, because that would impact his investigation and how he proceeded, whether or not he could ascertain whether or not.
I'm not disputing that, but your question was whether or not he was able to substantiate any voter fraud and he didn't do the substantiation of voter fraud on that case. Whether or not voter fraud was substantiated on that case was not something he did.
Your Honor, I'm not, okay, I'll rephrase the question because that's not what I'm trying to ask.
I realize that. That's exactly the point. So,
Okay.
to the extent you'll rephrase the question, the objection is sustained.
To, referring back to Constantino versus the city of Detroit, and specifically the allegations that you were asked about on cross-examination, as part of your investigation, did you find any support for those allegations?
No.
And how did that affect your investigation?
I took it into consideration with all the other information that was involved in my investigation.
I'm sorry, Your Honor, but just again, to the point that was made, the question I believe was, did you find any support for those allegations? Unless we can do an offer of proof, if the witness, for example, interviewed Jesse Jacob, who was the affiant in the case that I went through the affidavit of, or some of the others, and said, you said this in your affidavit, and then he decides it's not true, that's where he's deciding whether the allegations have any merit. But I'm not sure what he did in his investigation. I haven't seen any of that in the
The question was
discovery.
whether or not he decided that the allegations have any merit. Someone determined that those allegations didn't have any merit, correct?
Yes.
Not him.
Yes.
That's my thing. I don't think that's her question. Or that it's not her intent to make that the question. Whether or not he made the determination. I don't think it's disputed that he didn't do any investigation as it relates to that case.
Fair enough.
I think she's saying the ultimate outcome of that case was that there was no valid allegations sustained. Is that correct?
Yes.
Okay.
And did that ultimate decision have an effect on his investigation in this case?
Fair enough. And just
Exactly.
one other point that did come out on cross-examination. Most of those cases got dismissed on procedural grounds, never went to the merits. And that's important for this court, and it should be important for this witness to understand.
I don't remember you questioning about that.
I did.
That's, if they were dismissed on the merits versus,
That they were dismissed on procedural grounds and not on the merits.
No, I don't believe I was listed on cross. And
well, we have a record.
We got a transcript.
We'll check it.
Now, you were asked, I believe, today about King v. Whitman.
Yes.
And are you familiar with that case?
Yes.
And during your investigation, did you learn whether or not that case was successful on its merits?
I learned that the case was dismissed.
And how, if it in any way, did it impact your investigation, sir?
I took it into consideration along with all the other cases and information that I reviewed.
Now, are you aware of when, you know what, I'm not sure. Now, are you aware that King v. Whitmer went through several layers of the court system?
No, I'd have to refer to the case itself to, recall my time on
I heard his voice trailed off at the
it.
end.
I'm sorry, I'd have to refer to the case.
Okay. You say you couldn't remember, is that what you said?
Yes.
So, is it fair to say that without looking at a document to refresh your memory, would you be able to say when King v. Whitmer was first published in the Eastern District of Michigan?
I would have to look at the documentation for that.
related to King v. Whitmer was filed. It's at 505 Fed Supplement 3rd 720, a 2020 case. The author is Judge Linda Parker of the Eastern District of Michigan, and it was signed on December 7th, 2020.
Your Honor, I'm gonna object trying to pull this up and catch up here on the
Hold
fly.
on.
You can come over and look at it here too. if
Yeah,
that
I'm
would be
looking at the
helpful. I
docket
mean,
sheet.
If anybody has any doubt, she has the case pulled up right
Well,
there.
she's talking about the first opinion. What does
That's
the first
exactly what she
opinion have
said.
to do with whether the case was or not?
This was not dismissed.
I've provided the citation to the court. The court,
I'm giving them opportunity to pull up.
Yeah, Your Honor, as I'm going through, so my objection is, the question is improper. There's appears to be a December opinion, and so certainly the Attorney General's office is allowed to ask questions about that, but the case goes on well into 21 and looks like even 22. I know there were sanctions issues, but the thing that she's pointing to is a preliminary injunction order. So the case obviously goes on beyond temporary TRO request and relief, and it did. And
Judge,
there's still,
I'll just tell
You
you,
both can't talk at the same time.
I know,
okay, I'm done.
Okay.
I was part of that litigation. And so, the case was voluntarily
what are
dismissed.
we talking about here?
Wait, we're asking, so I'm just trying to
They're
clarify.
trying to establish.
She's
when you
asking
can-
us to stipulate or the court take judicial notice. We're objecting to it because it doesn't answer the question.
If I may,
Yes.
if I may, I think part of the problem when you're asking about the court to take judicial notice of, for example, one opinion on a docket, or there was a docket, it's not complete, and I think that is potentially misleading to the court. A possible solution is, because I know we are briefing things, is, for example, if the question was there an opinion on December 14th, whatever it may be, seems probably fine, given in light of the cross yesterday. But if the court wants to take judicial notice, or a party wants a court to, of a docket, an entire docket, I think that's much more beneficial to the court to see the litigation, not just when it started, not just when the first opinion was issued on a preliminary injunction, but also how long things continued on. I think that could probably clear up all of this.
Your question is particularly to this witness regarding, what you want the court to take judicial notice is when the case ended?
No. When the first opinion was issued on King v. Whitmer.
The first opinion on,
King v. Whitmer.
I know, on,
Okay, I object to relevance.
So, and look, I'm gonna join, just because I think for the court, if we're gonna do this, I stipulate, at least on behalf of Ms. Burton, that we can have the docket sheet printed for King v. Whitmer, and we will hand it into the court as the next people's exhibit or defense exhibit, and the court can certainly read a docket sheet.
I believe I am allowed to redirect when this is brought up in cross, and
I don't think they're disputing you redirecting, they're talking about me taking judicial notice, with the citation you're providing. That's what they're objecting to.
This is an opinion that was issued this day, nothing more.
yes.
Yeah, but it's not just that it was an opinion, I think the objection is that was the first opinion, is that the objection?
No, that's
My
not
objection is
the
relevance.
case.
Why is it relevant? It's an opinion in a case, it still pens after that date. So we're talking about the termination date is being.
I don't know if that was just her laying the foundation for a question.
It was. That has
So I don't know
not
what the
got to.
relevance is yet, but before we get to the question, there was, an issue as to the timeline of this first opinion. And so she, because he couldn't recall, was going to have me take judicial notice of when that opinion was, but there's an objection. So, I think I like the idea of just the stipulation to the docket sheet. I can read a federal docket sheet that resolves it. And I can determine whether or not the date of the first opinion based on that docket sheet. Now you can ask your question.
Okay.
Take your time.
Now, as part of your investigation, looking back specifically referring to King v. Whitman, did you take into consideration the opinion that was authored on December 7th, 2020?
Yes.
And based on your investigation, did that ultimately culminate in you drafting your affidavit for probable cause?
Yes.
I'm sorry, did that ultimately culminate, did the reading of a specific case culminate?
Yes.
Based on his
Yeah.
investigation.
Well, I thought your question was him reading of this opinion from December 27, 2020.
I said, did you take that into consideration? And then I moved on to another topic.
Oh,
Oh, okay, then I would drop.
Now, based on your entire investigation, the information that you gathered, did that ultimately help you author your affidavit for probable cause?
Yes.
The information that you received from Kenneth Chesbrough, did you receive that information before July of 2023?
No,
When did you receive that information?
it was shortly before December 6th, 2023.
Did you review the information that you received from Mr. Chesbrough?
Yes,
Did the information that you received from Chesbrough either support your findings in your investigation or lead you to believe that your findings might be incorrect?
it supported my findings.
And lastly, Commissioner Procedures, I'm going to hand you Defendants B and People's Exhibit 14. And first I'm going to ask you about Defendants B. And just could you remind us what that is, sir?
Yes, this is a document, it says State of Michigan Declaration to the Senate and House of Representatives. It's a recognition of presidential electors designated for Donald J. Trump and Michael R. Pence, signed by Kathy Burden on December 14th, 2020, notarized by Henrietta Toth.
During your investigation, did you come into possession of a signed copy of that document, Defense B?
No,
When did you come into possession of a copy of Defense B?
during the attorney proffer with Mr. Demeanor and Mr. Colbert.
Could you remind me of what People's Exhibit 14 is?
That's it's the memorandum and the certificate of votes for the 2020 electors from Michigan, Republican electors.
Now, going back to Defense B, during your investigation, were you able to determine who was involved in the creation of that document?
Yes,
And who were those people?
Laura Cox and Stuart Sandlin.
And does defense B contain alternate language?
Yes.
How many
Is
sig-
alternate.
Can you clarify what's alternate language?
What's alternate language mean?
Contingent language?
Thank you. How many signature lines, not counting the notary, are on defense exhibit B?
One.
Now going back to People's Exhibit 14, does that document contain contingent language?
No.
How many signature lines does that document contain?
We have 16.
Oh, sorry, just the signature page. I'm
Just the
sorry.
signature. Okay. 16.
And are there any signatures missing on the signature page?
No.
Now, I believe there are additional documents in line with the signature page. What are those again, sir?
This is the alternates that were selected to fill a vacancy.
And each of those pages bear how many signature lines?
2
Any signatures?
each. 2 each.
Any signatures missing on any of those pages?
No.
And that's the document that does not contain contingent language, correct?
Correct.
And during your investigation, which of those documents was sent to the National Archives and to the President of the Senate?
It's the People's Exhibit 14.
Thank you, Dr. Furman.
Excuse.
Yes, please.
Thank you, excuse. So, there was gonna be a new witness called, about 11:09. Who's our next witness?
The people have no further witnesses, Your Honor.
Your Honor, may we have a brief recess to?
We're going to have, we're gonna have lunch. I just wanna know who the witness is. Are you gonna determine if you need to call a witness?
Yes.
Okay,
Got it.
sounds good.
Could we have, you can nudge in 5 minutes?
Oh, okay, you can take 10 minutes in case someone has to go to the restroom, but I say we'll have to go way downstairs.
So just so you know, the state has rested and now.
The state is resting.
Okay, thank you, Your Honor.
correcting me.
Oh,
Okay, we're back on the record, and is the difference gonna be calling any witnesses?
Your Honor, I think I have what hopefully the court will perceive to be good news. We believe we presented our evidence through the people's case. We believe we elicited testimony through cross-examination of witnesses that supports our position that the court should not bind over at these defendants, and so the defense would not be presenting a defense case.
That's consistent with every other defense.
I'm sorry, Your Honor, that's correct as to Mr. Haggard, we are not presenting any witnesses.
Mr. Ahmed will not be presenting any witnesses.
Mary Ann Henry's not calling any witnesses.
On behalf of Ms. Fascinelli, Judge, we ask.
On behalf of Ms. Owen, we also ask.
Okay, so with that being stated, we, previously indicated that there will be bind over argument made by way of briefs, and not on the record, so that you can submit your writings. I'll give you a schedule for that. Counsel?
Well, in regard to that, Judge, we need transcripts.
That's fine, because I'm not gonna get my ruling until I finish the second batch anyways. So, you'll have time to do that.
That was going to be my question. So is the court going to key briefing schedule after the receipt of the transcripts, or just pick dates now?
Well, we have to see how long it's gonna take, or estimation, I should say, for the transcript. Typically, that's when you find out, correct?
Your Honor, if we're going to be waiting until after all of the other defenses have gone, I'd like an opportunity to see those transcripts as well.
I'm not gonna give you an opportunity to see those transcripts, just like they're not issuing bind over based on yours. You're issuing your bind over based on your presentation and who you process it. And then I will handle those, and then everybody will get their bind over argument at the same time.
Understood.
I mean, their bind over ruling at the same time, not argument. So no, I'm not gonna hold this over until 2025, so that we can, get everybody's transcripts, and hopefully it won't take that long to proceed with the others. We're scheduled to proceed with the next batch, I believe the end of May. Yeah, May 28th, 29th, 30th, 31st, June 3rd, 4th, and 5th. So I set a time, 7 days consecutively, so that we can run through this, understanding that it's gonna be more attorneys, so that means more cross-examinations, and more objections, more motions, so it may take.
I won't be there, Your Honor.
And that right there probably encompasses 3 attorneys. And so that, hopefully that 7 days should suffice to get that squared away. And so what I'll do is we will find out an estimation of when we can expect to have the transcripts completed, and from that you'll get notice from my assistant as to when you should have your bind over arguments for or against bind over, that is, into the court. Because I want to give you reasonable time to review those transcripts as well, okay?
Thank you.
Will there be an increase in the page limit? So I know right now it's 20, but there's a lot with 8 counts and all these days, citing law in fact, so I would request possibly 30 pages.
I was gonna ask you.
We already knew you were gonna ask.
I
That was what was going on in my head. Why would you encourage this?
Hey, send in the Marines, right? So, I would ask for 50. I think there's significant
I think 30 is a good round number. Like, I think you can make it concise, because, what do you put in there? You don't need to put more evidence in there.
Well, there's an entire analysis. I think the court has to first resolve the tension between state and federal law. There's a subject matter jurisdiction portion that has to be addressed well before the court even gets into the specific charges here, and then the facts as it applies to our client. There's a lot of legal issues that need to be resolved in this case. It's not as simple, here are the facts, here are the crimes, brief
Well, I don't really know that you need to go through the facts, cause that'll take more than 50 pages. But, I mean, if I give you 50, let me get my calculator, 50 times all the defendants, you know how much that is?
I do not envy your position.
We'll go with 300.
I understand, but
You want me to read 750 pages of argument?
again, I do not envy your position.
Well, I don't think that 50 pages is necessary. Mr. Silverthorne.
I'm gonna abide by quickly, I will, preface my comment with that. However, although this has been one session, the witnesses are testifying, are, I assume, virtually identical, and they make different statements. And so for the purpose of just raising objection to the record, I object to not having the transcripts of the other session. For that reason, there is sworn testimony on these material matters that are virtually identical, and the statement is made, that is completely contrary to a statement made, say, in our session, but we don't have. I think that would be relevant to the court's decision. Now, you will have heard it, we will not have heard it.
I'm not using their statements. The information coming from the other as to your client's bind over, because I'm also not gonna let you come in and now decide you're gonna cross-examine in that set of hearings either. You're not getting 2 bites at the apple. You can place your objection on the record. Good luck to you with that. We're not doing that. This was your time to ask all the questions and get all the information that you wanted in on the record, to present your case. You don't get to now wait until I begin another set, and I'm only waiting to give my ruling for there to be one continuous ruling, depending on how this goes. Has nothing to do with me trying to consider what they're presenting as it relates to your client or your client or your client, because that's not what we're doing.
And again, the reason I raise it is because some of the testimony was defendant specific. The majority of the testimony was case specific.
Doesn't matter, she has to issue all this testimony from scratch for these other people. You're not getting a second bite at the apple.
That's fine, I'm just raising it for the record.
Thank you.
Your Honor, Defendant Mary Ann Henry specifically does not join in that objection. I just want clarification that the decision on bind over is going to be focused only on the 4 corners of everything that was said here.
Absolutely.
And the court will not be considering any statements made.
It will not be
Thank you.
considered with anything that comes in with the second set, only what came in on this.
Thank you, Your Honor.
Judge, again, past the 50, but whatever the court says is what we'll be thinking.
Your Honor, would the court be amenable to, because this might even happen to go under 30, so for example, if Mr. Stavlin addresses, for example, the law on count 1, and we have really nothing to add to that, we would just be repeating that. Would the court be amenable to us saying, for example, we concur with the analysis of the law in Mr. Stavlin's submission, and then, if we believe there's analysis that's applicable to Mr. Haggard? I'm just thinking that might be more time efficient for the court than having to read all these lawyers restating the same law.
I completely agree to that, because if, just as you've done in the courtroom during this proceeding, if one person places the objection, you aren't all repeating that same objection or law applicable, you're joining in. And so to the extent that you all can do that, that would be wonderful, and that would help cut down on the pages. I am going to grant your request for 50 pages, but I'm going to highly encourage you to get it done in less than 50.
Thank you, Judge.
So that's 50 for all?
It's 50 is the max.
Okay,
for all.
but we'll definitely try to.
No, we have 16 cases, so like 16 briefs. She said, oh, so I was like, wait.
Well, all the
My co-counsel was concerned that we were limited
Oh.
as the people to a single 50-page brief, and I just said, no, that's not my interpretation of it.
You have 16
We have 16 cases, so
cases, so.
we will use our pages efficiently as well.
Thank you.
We'll be very efficient.
Not really so concerned about anybody other than maybe Mr. Demeanor and Mr. We know they don't want to leave any corners unturned. So with that being said, any additional matters before we adjourn today?
None for the people, Your Honor.
Are you anticipating argument or just on the briefs?
There will not be any argument, just on the briefs.
Very good.
And then you'll get, after I receive the briefs and when I'm ready, to give a ruling, we'll have another date set. But you'll get your dates, your next, date set after we can confirm about when we will get the finished, transcripts, cause I don't know how long that's gonna take.
Okay.
And I've seen some of the transcripts so far, so I know you don't need time to review, because I've seen a few boxes of transcripts, and I haven't seen the transcripts.
For the slow ones here, Judge. So you're gonna issue an order, it's gonna happen.
Correct.
Nothing further, thank you.
We're all set.
Nothing further, thank you, Your Honor.
Nothing further, thank you.
Thank you.
Everybody has the first 4 days of transcripts?
See, hope we don't see each other.
Yeah, we're gonna take care of